An order for conservatorship. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine Scale Form PC 640. Scale for State Court Administrative Office, PC for Probate Court, and the form is 640. You're welcome to contact my office. We'd be happy to give you the form free of charge. This form, a scale form, is used following the petition for a conservator, for an adult or a minor, but it is the end result of the adjudication after the petition has been filed, served, and there's been a hearing on it. So this form often is required of the court in advance of the hearing so that the court, after it makes its rulings, can simply sign the court order. But sometimes it's filled out and completed after the court has made its ruling. Nonetheless, this form is the required order after there's been a ruling on a conservatorship. If you're looking for a form relating to a guardianship, there's a similar style form, but this is the wrong one. This relates to a minor conservatorship or an adult conservatorship. Now remember, conservatorship relates to finances, the financial well-being of an individual. With all of the scale forms, they are created by various statutes as well as court rules. And as you can see from the floating arrow, there's a whole bunch of them here. The MCL, which stands for Michigan Compiled Law, those statutes, as well as MCR, which are the relevant court rules. So again, lots of different rules that relate here, and it's critical that before you go out and embark on a conservatorship petition or any probate-related issue, you're working with a skilled, competent probate lawyer who understands how to navigate through this process, because it's not intuitive. And there's no guidebook or rule book that you can simply go to just tell you how to do it. And the court personnel are not allowed to give you the answers. So working with a lawyer who's been trained in this area will give you huge advantages to understand language, process, save you money generally by being able to avoid the mistakes that often occur, as well as putting yourself in a lot of jeopardy if you do it wrong. So again, work with a skilled, competent probate lawyer. Let's work our way through the order itself. Top left corner is the county in which the conservatorship is pending. Top right corner is the file number or case number. In the middle, you'll see there's a checkbox for whether this applies to an adult over the age of 18 or a minor. So again, the form is versatile, can be used for both purposes. The next section is pretty intuitive. The name of the estate. And often people think the word estate means somebody has died, but in a conservatorship context, it is the term that is used for the file name. So the estate of John Doe, for example. They're a protected individual, the date of the hearing upon which the court has made the adjudication, and then of course the judge. The top part represents the findings of the court. So here, notice of hearing it was given or waived to all the interested persons. And there are court rules and statutes that dictate who is entitled to notice of a petition for conservatorship. So that doesn't have a checkbox because it's a requirement before any entry of any order would occur following a conservatorship, that the hearing notice was provided to all of the interested persons as defined under statute and court rule. Section 3 would be used if the court finds that the individual is not in need of a conservator. So in essence, the petition for conservatorship would have been denied. Section 4 identifies that by clear and convincing evidence, the adult individual, this is the section for the adults, is in need of a conservator because they're unable to manage his or her property and business affairs effectively because of, and there's a whole bunch of checkboxes. It could be mental illness, physical illness, mental deficiency, disappearance, etc., etc. Those are the relevant bases for the establishment of adult conservatorship in Michigan. And then the second part is the and part. Not only are they suffering from mental illness or mental deficiency or physical illness or age, but also the individual has property that will be wasted or dissipated unless proper management is provided. So there are times that people are are suffering from these various situations, mental illness, physical disability, but their financial assets are not at risk of being at waste or dissipated. They're actually being managed quite effectively, maybe with a power of attorney, or they're still able to manage it. So it's the and provision, and it has to be by clear and convincing evidence. So the court has to make an adjudication by clear and convincing evidence that 4 has occurred and the section A or B. So Section B relates to money is needed for the support, care, and welfare of the individuals or those that are entitled to be supported. So it's not that their own assets would just be at waste, but also that money that is needed for the support for themselves or others is also at risk. So again, either of those boxes on the and section can be completed, but you have to fill out the top and the bottom. Now, the next part, section 5, is another basis, and that is the individual is mentally competent, but because of age or physical infirmity is unable to do so. So although they are in good sound mind and they don't meet maybe the definitions above, just simply because of their advanced age or physical infirmity, there's a need for the conservator to effectively manage the affairs. And in fact, the person could simply say, I'd like a conservator because of my advanced age. I want somebody to assist in the managing of my financial well-being. 6 provides for the minor section. So this would be under the age of 18 years old. Upon presentation of clear and convincing evidence, the minor is in need of a conservator because A, they own money or property that requires management that cannot be otherwise provided. B, has or may have business affairs. And C, needs money for support and education and protection is necessary or desirable to provide the money. Now let's go over these. Typically, Section 8 relates to either an inheritance that they're about to receive or an accident, tort, negligence case in which they're going to receive a settlement or a verdict that has occurred. That money is coming into the hands of a minor. It's over $5,000 and it requires the court's protection. B can be simply that they're involved in business affairs. Maybe they've inherited a part of a business, or we've had cases where minors have started very successful businesses and start receiving lots of money, and that because of their minority, they need a conservator in place. So again, various bases for when a minor may come into the needs of a conservatorship. And often parents will say to me, well, wait a minute, why would I need a conservator? I'm the mother or I'm the father. We can do it. Well, under Michigan law, the answer is no. By virtue of them receiving this inheritance or settlement exceeding the sum of $5,000 in any one calendar year mandates the appointment of a conservator. So again, various bases for the conservatorship of both an adult as well as a minor. Let's keep moving down. Number 7, it is in the ward's best interest for the guardian to sell or otherwise dispose of property. Now, again, this is a very nuanced piece of Michigan law that relates to a guardian's ability to address certain financial affairs. We're not going to cover that piece. It's a little nuanced for this explanation. 8 is that there's no qualified person to act and that the appointment of a professional conservator is necessary. So the court has to make a determination that there is nobody suitable before they can go to what we call a professional conservator. And in that case, a bond must be filed. Number 9 is for purposes of the court determining how much risk there is for this conservatorship estate. The court evaluates the value of the cash and property that is liquid or readily convertible into cash. And the appointment of a professional, I'm mixing two things here, in the estate, and it exceeds the limit for administering the estate under the statute 700.3982. So the court makes a determination of the value of the liquid portion. So for example, if there's $80,000 sitting in a bank and there's $10,000 coming in a month, you take the 80 plus 10,000 a month, which is 120, add those together, you've got 200,000. And the court can determine that a bond would be filed to secure the performance of the conservator. So a bond is a guarantee of performance, and in the event that there's a breach of that performance, you can turn to the bonding company for the payment of the loss. So again, it's a protection for the person that's under protection. So interestingly, a bond is to guarantee the performance of the conservator for the benefit of the person that's under the court's protection in the conservatorship. Also, the court can say that the bond is not required because of certain reasons, and those check boxes are there for the court to make that decision. Let's go to the back side. This is really after the court has made findings, now the court is going to enter an order. And in this particular case, it's pretty straightforward. Under 10, the petition is granted, or maybe it's denied, or maybe it's withdrawn or dismissed before the court adjudicates it. Second is the conservator is not permitted to act until letters of conservatorship are issued. So again, in this particular case, if there's an adjournment or if it's withdrawn or granted for that matter, there's no right for the conservator to act until the letters of conservatorship are issued. It's a funny concept here because you've got a court order, but you're waiting for what are called letters of conservatorship, which I've explained in another video, and there are other statutes and court rules that relate to it. But it's a single piece of paper that kind of identifies that you're the conservator, any restrictions that are in place. But the purpose of this is that the court enters an order and may have other strings attached, like that you have to file a bond or take some other action. So the letters of conservatorship are evidence that those qualification requirements have been met and that any restrictions as set forth to the conservator are identified on those letters of conservatorship. Section 11 identifies who has been appointed, their address, and if they're appointed conservator or if there's any limitation on their conservatorship. So for example, some conservatorships have a limitation of what assets they're able to manage or restrictions on the disposition of certain assets. Section C identifies whether there's a need for what is called a special conservator under MCL 700.5423 subsection 3 in order to dispose of property. Again, very nuanced for purposes of this explanation. The next part is the qualification piece. So as I mentioned, you get appointed, but then there's a qualification requirement. It may be just that an acceptance of appointment is filed with the court, which is a form, a scale form, which I've explained in another video. Whether a bond, as we've identified before, must be filed. Whether there is money that is required to be placed in a restricted account, which is used often in minor conservatorships, so that they say, well, maybe we don't need a bond, but we're going to require the money be in a locked, restricted bank account. Nobody can access it without a separate court order. It's a way of protecting the asset without the imposition of a bond, which can be both costly and also for many people it's difficult to get a bond. Most bonding agencies require that you have an attorney, that your financial strength is good, you have a good credit report score. It also often, they want to make sure you have a job, no recent bankruptcies, no criminal background, to be assured that you're not at high risk. So a bond is not always easy to get. So there are other alternative ways that the court can try to find protections for the money to make sure that somebody doesn't steal or make mistakes relating to the assets. Now again, it reiterates what's stated above. The conservator is not permitted to act until the letters of conservatorship are issued. After qualification, the conservator shall comply with all of the requirements. And here are the requirements that include the inventory, the annual accounting, and all the requirements that, again, are not intuitive. There's no rule book that's going to tell you how to do all this. So that's why we keep urging you to be working with a skilled, competent probate lawyer who understands conservatorship-related issues. Because if you make a mistake, you are at risk of getting suspended, sanctioned by the court, put in all sorts of jeopardy, surcharge. So again, work with somebody who knows what they're doing. Again, number 12, if there's a waiver of the requirement for an annual account, which is required by statute and court rule, that box would be checked. And that if the court had appointed an attorney or a guardian ad litem for the individual that is being sought protection, this is the place for the court to say, you know what, you're done now. You're now discharged of that role. Don't confuse the term guardian ad litem with guardian. A guardian ad litem is quite different. And in a conservatorship proceeding, there's a right to an attorney for the individual that's being sought conservatorship over. So that's the area where the court can say, now you're done. We've made an adjudication. There's no need for that attorney to be appointed anymore, or for the guardian ad litem that the court had appointed, you're now discharged. And then a section for the court to add additional requirements or additional orders from the court relating to the conservatorship. There could be all sorts of things here, like that you can't sell real estate without a court order. It could include a limitation on the assets that the conservator is responsible, provisions for how a budget or a monthly allowance may be, all sorts of flexibility here. And then a space for the judge to sign a date. And then, of course, if there's an attorney involved who assisted in the filing of the petition, who's creating this order, that's the place for the attorney to fill out their information. Again, not an easy area to practice and to understand, and that's why I keep suggesting over and over again through this video, please work with somebody who knows how to manage their way through the conservatorship process. At the Probate Pro, we are passionate about everything probate. If you have questions about a conservatorship or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.